So welcome everybody. This is I couldn't even tell you how many we've done of these. The latest in a sequence of joint CPD events that Edinburgh Sheriff Court Mediation Service and Strathclyde Mediation Clinic have run together. It's our turn to host. We're hosting on Zoom. That's often the way of things, although I miss gathering and getting a wee chat and a wee sandwich. So it's nice to see so many people. I think I was speaking briefly to Sandy before we began. I think both services are experiencing growing demand, growing busyness. And I think between us, we're probably up to somewhere in the region of about 400 mediations a year being delivered to the Scottish justice system, which is it's becoming quite significant, and I think it's getting harder to ignore for policymakers, people who may or may not have a skeptical or positive view of it. So I think in that context, it's particularly helpful for us to keep having CPD, to keep working, improving our quality. I don't know if anyone noticed a little announcement from England and Wales. The Civil Mediation Council is planning to promote standards for mediation in the light of the growth in small claims mediation in that jurisdiction. So again, all good reasons for us to be doing what we're doing today. We have two speakers who are going to take half each, and we have from now till 2:30. So I won't hang about. I'll introduce each one. We have Patrick Scott, who works primarily with the mediation clinic and especially in Kilmarnock, and we have Margaret Downey from RGU in Aberdeen, but who works primarily, I think, with Edinburgh Sheriff Court Mediation Service. So I'll introduce each of them as before. So I'll say more about you, Margaret, in 3/4 of an hour. Patrick Scott, many of you will know. He studied, he arrived from South Africa as a senior counsel. And in this world, it would be a KC, but I think somehow the letters SC don't quite carry the same cachet, which probably allows you to escape some of people projecting stuff onto you that you may not want. And came to study with me and on the Masters. I was delighted and continue to be. Patrick's been a very stalwart contributor to the mediation clinic, and I think it's certainly at the moment our busiest mediator. He's going to talk about, I think, quite a tricky and interesting topic: unlawful or immoral agreements, an ethical dilemma. The whole business of what do we do when we, as mediators, have some alarm bell or some niggle or something ringing inside our heads saying, hang on, this just ain't right. So I don't know the answer, but I'm going to hand over to Patrick, who I think will help us think it through. Patrick, over to you.
Thanks, Charlie. Thank you for those kind words, and thank you everybody for attending the CPD. I have prepared some slides, mostly for my own purposes, so that I can take you through the discussion. As Charlie mentioned, this presentation is about unlawful or immoral agreements, and whether this creates an ethical dilemma for the mediator involved in a matter that is referred to mediation. In the January 2024 Mediation Matters, our clinic newsletter, I actually wrote an article called An Ethical Dilemma dealing with this issue. And the reason for writing the article, or the source of the article, was a mediation that I'd done with a co-mediator in, I think it was in December last year, for the mediation clinic. And I'm going to just briefly run through the facts, anonymized, of that particular mediation. It was about the unlawful lease of a car. Now, what had happened, I've called the parties Anne and John for the sake of anonymity, but Anne was disabled and she qualified for a subsidized lease of a motor vehicle. However, being disabled, she couldn't drive, so she wasn't able to get a vehicle to drive herself. But her friend John was actually looking for a vehicle, and the rental to pay for the subsidized vehicle was very low. So he was quite happy to enter into an agreement with Anne whereby she would lease the subsidized vehicle at a reduced rate, and he would pay all the costs. He would pay the deposit, he'd pay the monthly rental payments, and for all intents and purposes, he would fund the car. However, in return, uh, he would be able to use the car for his own purposes whenever he wanted to. You basically treat it as his car, but Anne would be entitled to ask him to take her places when she needed to go anywhere. Now, when this arrangement started out, it worked quite well. Whenever Anne needed a lift, she'd contact John, and John would go and fetch her, and he'd take her to wherever she needed to go. But in time, John got a bit tired of this, so he started not responding to her requests. And as a result of this, Anne got a little upset, and she went back to the funder, the party who had subsidized the vehicle, and she said that she wanted to get them to take back the vehicle, to repossess the vehicle. As it turned out, the agreement that she had with the funder, the party who provided the subsidy, had a specific term in it that prevented her from allowing anybody else to use the vehicle. She could have a driver, she could have somebody to drive her in the vehicle, but it was a specific term that she couldn't allow anybody else the use of the vehicle for their own purposes. So she reported this to the funder. I'm going to call them the funder, and they repossessed the vehicle, and they refunded the deposit to Anne, and there was no more a vehicle available for either party. So John was obviously quite upset about this. He paid the monthly rental payments for some time, and he'd in fact made an additional payment because he was paying the monies to Anne and then she was paying the funder. He'd made a payment that didn't go to the funder because she'd already got them to terminate the agreement. So he sued her for repayment of the deposit and some other monies, and the matter was referred to mediation. When they came to mediation, we went through the matter, had pre-mediation meetings with the parties, started in a joint session, and it was only late in the mediation that it transpired that there was this term in the agreement, in the rental agreement, that prevented Anne from allowing anybody else to use the vehicle. So essentially, the agreement that she had with John regarding the funding of the payments and the deposit was an unlawful agreement. But as I say, we only discovered that late in the mediation. Thereafter, the matter settled. The parties agreed that Anne would refund certain monies to John, and we had a settlement. After the matter concluded, we did a debrief, and my co-mediator and I discussed the issue of the morality of the agreement, the ethical dilemma surrounding us dealing with this matter at all at mediation. And as I mentioned, I then wrote an article in the January issue of Mediation Matters, and I looked at some of the authorities, which I'm going to share with you briefly. I looked at Irma Shapira, his book, A Theory of Mediators' Ethics, where he deals briefly with the general idea of a mediator's duties and responsibilities in this regard. He says mediators' responsibilities are not only to the parties, but also to the profession and the public. They're responsible that the process of mediation is not abused and that its outcomes not harm important social interests such as the rule of law, the rules of critical morality, and the institution of mediation. So those are sort of general terms relating to what our duties are as mediators. Then in Ellen Waltman's book, Mediation Ethics, she deals with this by way of a practical example. And her example, her case study that she refers to in the book is not dissimilar to the one that we dealt with. I've just briefly highlighted the basic terms of this agreement. There was a loan agreement between two parties. The one party was funding the small business venture that the other party had entered into. The venture failed, and the borrower who'd lent the money was not repaid. Sorry, the lender was not repaid. The lender then sued, and the matter was referred to mediation. During the mediation, at the end of the joint session, it transpired that the business that was being funded by the lender involved the import and sale of illicit drugs. And this was something that the lender was aware of. The mediation continued, and a settlement agreement was reached whereby certain monies would be repaid by the borrower to the lender. Now, Ellen Waltman in the book deals with the comments of three commentators on the facts of this case, what their feelings were, what their attitude was to the mediator having done the mediation and taken it through to a settlement agreement. The first of those was John Bickerman. He was not in favor of the mediation having continued. He was not in favor of the mediator having taken the parties through to a settlement agreement. And his comments were along the lines of, there's a line between ethical and unethical behavior that can be fuzzy, but there's no haziness over conduct that crosses the line into sanctioning, participating in, or hiding criminal behavior. And his comments, as I say, which are that the mediation should not have continued, seem to be premised on the fact that the illicit drugs deal, the nature of the business of the borrower, had not been discovered by the authorities. However, that was incorrect. The authorities were actually aware of the nature of the business of the borrower, and they had confiscated his drugs, and they attached certain monies and so on and so forth. And that was, in fact, one of the reasons why the borrower had not repaid the lender. He didn't have the funds to pay. But as I said, they did ultimately reach a settlement. So John Bickerman was of the view that this was something that should not have been dealt with at mediation, that it was a matter involving the sanctioning, participating in, or hiding criminal behavior, and that no mediation should have taken place. Jeremy Lack had a different view. He was of the view that each mediator should rely on his or her own values and ethics. And he importantly distinguished between the legality of the initial transaction, the agreement whereby money was lent to the borrower for purposes of this business venture, and the legality or illegality of the settlement agreement. So his view was that regardless of the nature of the original agreement, as long as the settlement agreement is legal, there's no problem with proceeding with the mediation. He says the question becomes ethically challenging only when the mediation itself may facilitate the commission of a crime. The third commentator is Julie McFarlane, who actually did the mediation. She was the mediator who did the matter and got the settlement agreement. And she gave her views and her commentary in the book, in Ellen Waltman's book. And she says her objective was to assist the parties in finding a lawful and non-violent solution to their dispute. Proposals that were made were to resolve the dispute and did not involve illegal behavior. And like Jeremy Lack, she says the distinction between further illegal conduct and resolving the consequences of such activities is important. So she similar to Jeremy Lack, distinguishes between the legality or otherwise of the initial agreement and the legality or otherwise of the settlement agreement. So that was more or less what I discussed in the article in Mediation Matters. And I concluded the article with the following. I said, what is interesting from the above is the different approaches adopted by the three commentators. What would you do? A CPD session will be held by the clinic later in the year to discuss this issue. Details will follow in due course. Well, today is that CPD session. What happened thereafter, which gave me a further idea with regard to today's session, was I received an email from a mediation group in South Africa who'd read the article. And I'm quoting here from the email. The person who sent it said, arising from your last contribution in Let's Mediate. That was actually an error. It was in Mediation Matters. I also write for a mediation newsletter in South Africa called Let's Mediate, so it got the names wrong. Re a loan that was for drug dealing. We had a robust discussion among panel members and interested parties in this regard. The upshot was that all agreed that having mediators' guidelines for potential grey areas such as these would be helpful, if not advisable. So what I thought we should do is we should look at that very issue. We should see whether there are guidelines that we could formulate that would assist mediators when confronted with a matter of this nature in determining whether or not they should proceed with the mediation. So what I would like us to do in breakout rooms, if Pauline or Rosie would be kind enough to create some rooms for us, is to consider whether there are any guidelines that we could formulate which would help to provide a reference for mediators. And in discussing these guidelines or potential guidelines, perhaps consider, amongst other things, some of the following. Does it make a difference if the illegality is known to the affected party and or the sheriff? Does it matter whether the settlement agreement is legal or illegal? If the respondent will benefit at the expense of the claimant, if a settlement's not achieved, is that a factor? In the example that I referred, the mediation I did in December, would it have made a difference regarding the settlement agreement if the deposit had not been refunded by the funder to the respondent? Would that have made a difference? Will it matter if the court will not enforce a settlement agreement if the respondent doesn't perform? Because courts, as I'm sure we know, other than in certain exceptional circumstances, don't enforce unlawful agreements. They won't sanction unlawful agreements. Now, if this matter, if this mediation resulted in a settlement that the respondent didn't comply with, and the matter went back to court under the same case number, if the case had been paused pending performance of the settlement agreement, would the sheriff say, well, since the original agreement was unlawful, I'm not going to enforce the settlement agreement? Is that a factor that should play any role in determining whether the mediation goes ahead? Do the terms of the settlement agreement make a difference? Do they resolve what the parties are intending to resolve? Or do the terms of the settlement agreement themselves contain an illegality? Okay, I think everybody's back. Apologies, everybody. My computer decided to reboot or whatever you call it and just shut down, and I had a blue screen and everything was re-uploading or whatever. So I was just taken out of the meeting. I guess that's one of the downsides of Zoom, as Charlie was saying. Besides not being able to have sandwiches and a cup of tea together, you also sometimes just get kicked out of the meeting. So apologies. But thankfully, sorry, Charlie.
I was just going to say you probably got about 6 minutes, 6 minutes or so for feedback, if that's okay.
Great. That's perfect. Thank you. So, can we have that? I'm not sure how many breakout rooms there were, but I would love some feedback from them.
I think there
So,
was six, Patrick.
okay, thank you, Pauline. I'm going to stop sharing now so I can see more people on the screen. Can we have some feedback? Who is in breakout room 1? Can we have some feedback from there? Any guidelines you think? Leon, are you going to give us some?
Yes, yeah, I managed to get suckered into being the feedback person. So I've got to acknowledge that we didn't really address your questions at all, frankly. We discussed I think there was a consensus in our room that the moment that anything becomes clearly criminal, that we would all seek to recuse ourselves, as subtly David was saying about doing so in a way that you don't tell the parties necessarily why, in case there's a danger to yourself in doing so. And we were all fairly on the same page that in that situation, confidentiality completely goes out the window. And that if there is criminal activity or potential harm or any safeguarding risk, that we would all feel quite comfortable um, sharing that with the relevant authorities. The more tricky question around the civil element, and I think I raised a point that I'm curious what anyone else would make of that. It depends when you come across the difficulty. So I think in your case, you were saying, Patrick, that towards the end of the mediation at the debrief, it became clear that actually, hang on a second, this was, there was dodgy dealings going on at the basis of this. And we would say that maybe in that situation, you had an addendum or something to the agreement set reflecting that to a relevant authority. But when you're there in the room, I don't think we had a clear sort of sense as to what the right thing to do in every case would be. So in all honesty, not the most helpful of feedback and certainly no guidelines from us, I wouldn't say. But if anyone in the room there's something that I missed out, please do add it.
Okay, it doesn't seem that there is. So can we go to the next breakout room, please? Room 2, who is in room 2?
I think that was us, wasn't it? Um,
Well,
Adrian.
whichever
So,
one you were in, Charlie, maybe you can just give us.
no, I think it was room 2.
Okay.
Well, maybe yeah, because Adrian said a fair bit, and I'll feed that back. One of the things that emerged was if a mediator doesn't have knowledge of the law, that can act to deprive them of something other than their own morality. And I think one of the things that came across was quite a lot of wariness of applying our own morality because morality is such a subjective and often not universal. So I kind of picked up a caution about that and the sense that the people with a legal qualification or legal understanding almost got a get out of jail free card in saying, well, I know the law and it says this is, and that kind of means you're not relying on your own morality. However, I personally think you're any one of us always has the right to withdraw and say, I don't want to be part of this. And you could think of more extreme examples. Just one other thing with the clinic director's hat on. I do sometimes think about the Daily Record headline, mediators facilitated what? So, there's another consideration. I think Omer's piece highlighted that.
Great. Thanks, Charlie. Breakout room 3. Anybody from there? Nobody. Okay, breakout room
Hi.
4.
Oh,
Sorry.
sorry.
Right.
Sorry, no, I was just going to say briefly, I was in breakout room 3 and we kind of talked a little bit about the example you had gone through in your experience, Patrick. And I think ultimately the general consensus was that people would be okay in facilitating that mediation. I mean, initially I was saying when I heard it, I was thinking, oh, this can't be right if the actual agreement or the contract, the basis initially appeared to be carried out in an unlawful way. But I think talking through some of the issues, it was felt that people would be very comfortable in pursuing that mediation if the parties were able to come to some sort of agreement. But it didn't get on to sort of the more wider issues. There was mention of if there was maybe criminal behaviour or unlawful behaviour that the parties were currently involved in that came to light, that might be different.
Great, thanks, Carol. Thanks for sharing that. Next breakout room 4. Anybody there who will give us some feedback briefly?
Well, Patrick,
I think
we got into practicalities such as, you know, how does the illegality get uncovered? In your case, it seems to have happened quite late in the process, and people were interested as to whether or not, you know, so firstly, might the sheriff uncover it in actually looking through, and then secondly, when it came to the mediation service, might they uncover it? So we were interested in the process by which that illegality might be uncovered. We then also talked about the timing within the mediation process of when the illegality emerged as to whether or not that is material. Because in your case, clearly, it happened quite late, and this would, in reality, this would happen because as you uncover layers and layers within a mediation, it may only then be that the illegality makes itself clear. And lastly, I guess we also sort of raised the question as to, well, was there a victim, particularly in your case? So did anybody actually lose out in the process of the agreement that you actually facilitated? And that filled our time quite nicely.
Great, thank you. Breakout room 5 and 6, we've got a couple of minutes left, I think. Breakout room 5, is anybody there with a bit of feedback?
We had a bit of feedback. We looked at one of the questions would be the consequences of withdrawal. What would happen if we withdrew from the mediation to the parties involved? Would that be a question that we should take into account? There was something about the mediator and the citizen. What would be your obligations, and are they different? I think there was a wee bit of agreement that if the settlement agreement wasn't in itself illegal, that might be something to consider. And the only other thing I chucked in is that Scottish Mediation are working on a guidance document to go with a new code of professional conduct. So I'll be very interested to see your conclusions, because it's a wide-ranging document, and something of this sort of dilemma might be a useful exemplar to put into that document.
Great, thanks for that, Graham. That's very useful, thank you. And finally, room 6, if we've got a minute left. Anybody from room 6 give us a minute's feedback?
Patrick, sorry, Sandy. No, I was just going to say, Patrick, in my experience, a sheriff would not necessarily not refer a case to mediation if he had suspected alleged illegality. The cases are referred in practice, even where there is alleged illegality.
Okay.
Yeah, and in room 6, we said that you probably come across reference to illegal behaviour more than you might think. So, you know, threats of violence or things that have happened in the past, which are not necessarily related to the immediate issue before you. And we discussed that sort of distinction about how much the activity was related to what the settlement agreement is doing, but also where the duty might fall upon you to report that. And that's where we were all a bit of a loss in terms of obligations, not just sort of the ethical side, but what legal duties there might be. So I think we all agreed it very thorny questions worth more consideration.
Great, thank you for that. Thank you all for the feedback. It's very, very useful. And my idea is to write a follow-up article in Mediation Matters, either in the next issue or the one thereafter, dealing with some of these comments and some of these approaches. So thank you very much for that. And I think my time is up, so I'll hand back to Charlie. Thank you, everybody, for participating.
Thank you, Patrick.